We take you back here now. It's been 18 years since the International Criminal Court was established in 2002. Let's find out how it's fared now. I'm joined by Professor Dire from the University of Pretoria. Thank you very much for joining us again. Let's try this. So, your assessment of the court's performance over the 18 years.
Yeah, so as I was saying, it's really been a mixed bag. There's certainly been lots of successes, both in terms of just having the symbol of a court like the International Criminal Court that has the competence to try those that are guilty of the most serious crimes under international law, but also in terms of development of laws. So it was under the Rome Statute that there was a process to identify the definition for the crime of aggression, the crime of crimes, and I think that was a success. There have been a number of successful prosecutions and convictions. And even in those cases where there were acquittals, one can see successes in the sense that law was being developed by the court. But certainly there were also lots of challenges, and I think you mentioned some of them. The major challenge, of course, coming in the relationship between the International Criminal Court and the body of states that form the bulk of states parties, namely African states parties, and in particular the African Union. I think that's been certainly the major source of contention, and at some point there were question marks raised about whether or not the ICC can withstand that particular challenge.
Let's expand on that. There's a widely held view that the African continent is on trial at The Hague. Is this a fair assessment given that we refer those cases?
Yeah. So I always say to my students whenever I talk about this that that there's always different ways of looking at it. And in fact, those on both sides of the aisle have some points. And so there is some accuracy. But that there are also important flaws in both arguments, right? And so if I take those that, for example, say the African continent is on trial, the big problem with that is not so much the self-referrals. I'll come to the self-referrals in a minute. The big point is, of course, it makes sense that most of the prosecution and most of the cases would be on the African continent because this is simply where we find most of the conflicts, right? So from that perspective, it makes sense. The other point to make about this, of course, is this has always been the case. I mean, from the time that the ICC began its operations, it was a case that all the situations and all the cases were from the African continent, but we really only begin to see the African Union complaining in 2008 with the indictment of a head of state, right? So it's only with a sitting head of state that you see African states beginning to complain, which raises the question whether it's really an issue of principle or whether it's, as some like to say, protection of one of our own. If you turn the coin the other way and you ask yourself the question, it can be argued that all of these situations are self-referred. There's two responses to that. So one response is to say, well, that's not accurate, right? So not all these situations have been self-referred. Some of them have been self-referred. But even those that have been self-referred, if one digs a little deeper, one finds that these self-referrals were a kind of a quid pro quo. So in the early days of the ICC, the first prosecutor was very keen to make sure that the ICC has some legitimacy. So he went to states with conflicts and he basically stuck a deal with them. Refer these situations to us and we will prosecute your enemies. I mean, think about it. In the DRC, where there's a conflict, a fully blown conflict, the only defendants don't come from the government side, right? So it's a perpetual thing where when all of these self-referred cases, the government is never itself prosecuted, as if the government in a conflict situation never commits war crimes or crimes against humanity. So that should tell you something also about the value of these self-referrals and the arguments that's based on self-referral. The other thing, of course, and this for me is a major question, right? So for me, the major question is, one of the responses from the ICC is we often aren't able to investigate those situations that are outside the continent because we don't have jurisdiction. The reality is that in many of the situations that we speak of, the court does have jurisdiction. So Afghanistan, of course, has already been opened, but the court was considering open investigations in Afghanistan since 2007, right? And it was only in 2008, it was only in 2019 that the court decided that it would actually open up a real investigation. The same thing can be said about Iraq, where the situation had been under preliminary analysis for a long time before a decision was made. You can also make a similar point about the situation in Palestine. So it seems as if whenever the court is faced with a politically sensitive situation which would upset the big powers, the court thinks very carefully about whether or not to open up investigations. Whereas in Libya, I mean, it was handed the situation by the Security Council in March. In fact, no, it was in February, and already by March you had not only an investigation open, but you had 3 indictees, right? So if it's Africans, the court is not shy to start investigations quickly, but if it's more powerful states that may be implicated, the court is very careful. Even if it wants to open investigations, it's very cautious. I mean,
Professor Dire, unfortunately, we're so tight for time, but perhaps in closing, you know, let's use the African proverb, African problems, and let's find African solutions for African problems. And we look at the African Court of Human and People's Rights. What has been your assessment of that body of the African Union?
So, I mean, look, the African Court is, of course, functioning. There was, in 2014, a protocol which was adopted, which would extend the jurisdiction of that court also to serious crimes. That particular protocol, to be honest, is very problematic in terms of its drafting, in terms of its content. As a matter of principle, I have no difficulty with it. I know that many do. But there are many issues in that protocol that I think have to be resolved. And as a matter of fact, it doesn't have enough ratifications to enter into force. And I doubt that in its current shape, it would enter into force.
So much more to go into where this is concerned. But for today, that will be enough. Thank you very much, Professor Dire Tladi. He's the Professor of International Law at Pretoria University.